assistant professor of sociology at New York University and holds a PhD from the University of California. His book, Conservatorship Inside California's System of Coercion and Care for Mental Illness, is available from Columbia University Press and examines California's system of involuntary treatment from the perspective of clinicians, policymakers, families, and the clients of the systems themselves. His work has been featured in New York Times, Los Angeles Times, Washington Post, San Francisco Chronicle, and The Economist. And he's currently working on a book about the public mental health system in France. So again, thank you, Alex, so much for joining Nami Marin this evening, and I'll pass it over to you.
Well, thank you very much for that kind introduction. Thanks for inviting me, and thank you, all of you, for taking a little bit of time out from your evening. I am excited to be virtually speaking in Marin. My dad grew up in Mill Valley, and I used to spend a lot of time there with my grandparents. So I'm imagining where you all are, and I'm sort of jealous. I'm based in New York now. Okay, so I'm going to share my screen. Hopefully everyone is seeing not my notes, but the slides. Let me know. Okay, great. So my work on this topic began with my dissertation at UC Berkeley, where I conducted a comparative study on decision-making in public mental health care in France and the United States. Towards the end of my PhD, I began hearing about proposals to expand the use of conservatorship across the Bay in San Francisco. Policymakers wanted to use involuntary treatment to manage the nexus of homelessness, substance use, and urban disorder that I could see every day on my bike to campus. Yet I quickly realized there was almost no academic research or government oversight into what was currently happening to people already on conservatorship. And my attempt to provide some of that analysis culminated in my book, which was released in September 2023. What I'm going to share with you today is to show how what I call the state's abdication of authority over the conservatorship system has led to an excess of coercion that produces neither social control nor transformative care. Now, before I begin my talk, I want to offer two disclaimers. First is, I realize, many people come to NAMI because of a really practical challenge, which is trying to get care for themselves or for a loved one. This talk is not a primer on how to get a conservatorship or how to navigate the conservatorship system. My real goal here is to try and give a different perspective as to how that system is functioning and some ideas for the sorts of reforms that we could be advocating for. Second, this is going to be a talk that paints the conservatorship system in a pretty harsh light. As sociologists, we're trained not to think about why people make bad choices, but why people are often left with no good choices to make. And so this is really a talk that is not criticizing the clinicians, the family members, the clients who are struggling in this broken system. It's actually about how this system is sort of dysfunctioning despite their often quite heroic efforts. I'm hoping you have a miracle. I'm sitting in the passenger seat of an SUV, shadowing a paramedic responsible for trying to care for some of the most vulnerable people with mental illness in one of California's major cities. We get a call from the discharged social worker at a nearby private hospital about a patient in their ER. She's 14 weeks pregnant, meth use disorder, schizophrenia, homeless, and hospital administration is saying, "You've got a discharge." And I'm like, "To where?" I'm hoping you have a miracle. We looked the woman up in the city system. She's been recently revived by firefighters after an overdose, refused shelter offered by an outreach team, and been transported involuntarily several times to ERs after running into traffic. We run through our options. It's nighttime, so the shelters are full. A detox center won't take her because she's pregnant. A program for pregnant women won't take her because she's mentally ill. And the psychiatrists at the hospital are saying to release her, claiming her main problem is meth. This war zone-like triaging of scarce resources was something that I witnessed over and over again throughout the state, as suggested by some of the photos you see. So we brainstormed three ideas. The first is to beg the hospital administration to keep the woman overnight as a social admission, which means they won't get reimbursed for her care. The second is to let her walk out of the hospital and pick her up when she's far enough away that we can take her to another ER. She's been heavily medicated, and so this is unlikely to work. The third is to pass the hat around the outreach team to pay for a hotel. It's a Sunday night in the world's 5th largest economy, and that's our best option for a homeless, pregnant, mentally ill person. We pull up to the hospital. A nurse from the public health department comes out and tells us, this ER doc is furious with hospital admin. She says this woman needs to be held. She needs to be conserved. It might surprise you, but the miracle that the doctor, the first responder, the nurse, and the social worker are all hoping for is a conservatorship. So what is a conservatorship? Maybe everyone here knows, but as a quick primer, conservatorship, also known as a guardianship, is a legal measure that grants the third party the power to place someone in a locked facility, order them to receive treatment, and control their finances and personal decisions. In California, a person with mental illness can be placed on a conservatorship when they've been deemed gravely disabled, which means unable to meet their need for food, clothing, or shelter as a result of a mental disorder. Now, for many people, the first time they heard about conservatorship came in 2021. Then, thanks to a burgeoning Free Britney Spears movement, California's normally hidden conservatorship system burst into public view. The pop star's experience of 13 years of exploitation and abuse at the hands of her father fueled a view that conservatorships are overused, abusive, and paternalistic. As the ACLU states, conservatorship is, quote, the greatest deprivation of civil liberties aside from the death penalty. Yet as the story I open this talk with suggests, there's another view, that conservatorship is a life-saving intervention that is being grossly underutilized in the face of California's intertwined crises of mental illness, substance use, and homelessness. Indeed, according to Governor Newsom, pictured here for advocating for loosening the definition of grave disability, it's actually California's strict conservatorship laws that have sentenced people like that young woman to death. So who is right? Is conservatorship overused and abused, or is it a compassionate intervention that is being neglected due to civil rights protections? My somewhat paradoxical answer that I want to try and convince you of is that the answer is both. What I want to show is that right now the public mental health system in California is producing both frequent, ineffective coercive interventions and abandonment, abuse, and death for people whose needs are not being met by voluntary treatment or independent housing. And my argument is that these twin tragedies reflect what I call the state's abdicated authority. As I'm going to show, the state has declined to organize and regulate the conservatorship system, dispersing government power within a fragmented, privatized field of actors that makes up a supposedly public mental health system. In so doing, it has avoided the difficult and expensive challenge of how to create an accountable treatment system for people with the most serious illnesses. This abdicated authority has three consequences for reform. The first is that legal changes, which are intended to make it easier to get people into conservatorship, often don't get implemented at all. Instead, legal criteria function often as an excuse for denying care to people for whom no resources are available. Second, new resources don't always get allocated fairly or effectively. Some of the most needy people are still left out, even in moments where the system expands. And third, involuntary treatment, when it does get imposed, often doesn't lead anywhere due to problems in the quality of care and a lack of coordination. So I'm going to do this talk in three parts. The first, I'm going to give you some background and some context for how we got here in California. The second and the biggest part of my talk is going to be my field research, so what I observed on the ground. And the third part, I'm going to talk a little bit about reforms and my own recommendations. As a quick sort of overview, why am I talking to you about this? So my investigation really rests on interviews with stakeholders. I interviewed 282 stakeholders working across the conservatorship system from 33 of 58 counties around the state, mostly from 2018 to 2022. I also shadowed outpatient providers and emergency responders. I sat in on conservatorship courts, and I visited a range of residential treatment settings. I also reviewed government reports, administrative statistics, and newspaper articles on California's involuntary treatment system reaching back to the 1950s. And I've also been an active participant in some state policy working groups around conservatorship and long-term care. Okay, so part one. So for the first part of my talk, I'm going to discuss how we got here. It's been almost unquestioned since the pandemic that the US is in a mental health crisis. But I want to talk specifically about the set of conditions under which a subset of people with the most serious illnesses have become particularly visible, particularly vulnerable, and particularly problematic in the public's eyes. And I'm going to focus on four factors here. One is the role of state disinvestment and disengagement. Second is a new wave of deinstitutionalization. The third is a degradation in the conditions of the unhoused population. And fourth is a system of repeated and ineffective involuntary interventions. But before we do that, I want to go a little bit even further back in history. So for some commentators, some of you might have heard of it, but for some commentators, the origins of the present crisis in California lies in a landmark piece of legislation called the Lanterman-Petraeus Short Act. So in 1963, a group of California legislators embarked on an investigation of the state's hospital system, which at that time housed 35,000 people and was the second largest state agency after the University of California. What they discovered was disturbing. One boy was locked naked in a bare room, blue from the cold. Staff reported that patients had died after being beaten. What's more, they learned that patients could be permanently committed by hospitals by judges after hearings that lasted just 5 minutes on average. The report described hospitals as, quote, a bin marked miscellaneous to receive every personnel problem facing society. In 1967, legislators announced their intention to end what they called the inappropriate, indefinite, and involuntary commitment of the mentally ill. The Lanterman-Petraeus Short Act, which was hailed as the Magna Carta for the mentally ill at the time, created a host of new legal protections. They put an end to indefinite commitments and replaced it with a series of time-limited procedures with intensifying judicial oversight. And the end of that process is a conservatorship. Within a few years, as you can see, newspapers declared that the act had restored the basic civil rights as human beings of mentally ill people. And this bill was a template for reform around the United States. That said, LPS has become a kind of boogeyman for all that's gone wrong with California's mental health system since. However, I want to shift attention away from that law and towards a broader failure of government. So as you can see, the LPS Act came amidst an ongoing sharp decline in beds in state-run facilities, from 37,000 in the mid-50s to around 6,000 today. But abdicated authority has been an ongoing process. And I'm going to offer three, without going through the whole history, I'm going to offer three examples. So first, the state has repeatedly devolved responsibility for mental health services to counties, which in turn have kicked the organization of care for the most chronically ill individuals to private operators of residential treatment facilities and boarding homes. Second, the system has been subjected to brutal waves of austerity, and not just under Ronald Reagan. As recently as the Great Recession, 1/3 of clients in the public mental health system were expelled from treatment. While in other moments, California's system has rapidly expanded, these oscillations have created a population that is understandably distrustful of offers of services. And finally, the state has offered enormous discretion to actors on the ground about how to actually implement laws around involuntary treatment. So in recent years, for example, the legislature has created new mechanisms of involuntary treatment, like court-ordered outpatient treatment, also known as Laura's Law. But these have been adopted unevenly with very little oversight or funding. And in fact, the state closed its Department of Mental Health in 2012, and with it, the office that provided technical assistance and monitoring of conservatorship programs. This delegation of care to the private sector has had particularly problematic consequences in recent decades. When people left state hospitals in the 1960s, most were not unhoused, but they instead went into facilities like nursing homes, rooming and boarding homes, or starting in the 90s, prisons and jails. Today, however, the state is experiencing a new wave of deinstitutionalization. So many of the options to contain people with serious mental illness in a place like San Francisco have shriveled due to rising property and labor costs, community resistance, and tightening insurance reimbursements. We can see drops of 50% for acute psychiatric hospitals, 29% for nursing homes, and 37% for board and cares. Now, some of these changes are positive, like a 46% decrease in the number of people defined as mental health cases in jail. But many of these individuals have not gone to community-based housing and treatment, but onto the streets. The third factor I want to highlight is the way that conditions on the streets have deteriorated. You probably don't need me to tell you that California is home to 180,000 homeless people, which is half of the population of unsheltered homeless in the US. By various metrics also, the condition of the homeless population has degraded. As you can see here, drug overdoses in San Francisco have spiked dramatically over the last decade, driven by fentanyl, a powerful opioid, and methamphetamine, a stimulant. Although only 1/3 of the overdoses you see here among homeless people, I think this chart is kind of offering a rough proxy for some of the strain that homelessness is placing on our social service safety net and the disruption with which it has become associated in the public's eye. homelessness has also become much deadlier. So this chart shows a calculation of yearly homeless deaths in major counties versus the point-in-time homeless count. Los Angeles went from 500 homeless deaths in 2014 to over 2,000 in 2021. In short, politicians like Governor Newsom are correct when they say that California is experiencing a profound mental health crisis that is being fed by decades of state disinvestment, the downsizing of treatment and custodial institutions, and new and lethal substances that are impacting a highly vulnerable unhoused population. But they're also making another crucial claim, which is that one aggravating factor is that California's laws, again, that's the Lennerman-Petra Short Act from 1967, make it too difficult to force people into care. And I think this is the experience that many, many families have. But on this last claim, one last piece of data is really important. So surprisingly, this graph shows that comparatively, California actually has a high rate of involuntary interventions. The top bar shows short-term holds or 72-hour detentions for evaluation, like that experienced by the young woman whose story opened this talk. Even for longer-term 14-day civil commitments, California has a higher rate than many European countries. Until recently, however, the number of conservatorships, those are these long-term guardianships, was declining. A temporary conservatorship, it lasts 30 days. A permanent conservatorship lasts 1 year. You can see that until recently, both of those were going down. In fact, in 2000, there were over 15,000 conservatorships in the state, and by 2018, that had dropped to fewer than 5,000. What you're seeing here is that California has a system that is engaged in repeated coercive measures that are not leading anywhere. We often talk about this as a debate between people's civil rights and medical care, or between law and medicine. But in reality, in California right now, neither of these is winning. Many people are, sort of neither having their rights protected nor receiving any kind of, stabilizing or transformative care. And to explain this, I want to talk about what some of the consequences of the state disinvestment in the system look like on the ground. So the LPS Act made conservatorships difficult to get by design. So in order to be conserved, somebody has to pass through these 6 different stages I'm putting on this flow chart. So first, a person has to be placed on an emergency hold and transported to an ER, which has to admit them. The hospital then has to make an application to the county public guardian, which investigates the referral and brings a petition to a court. The court then rules and orders the person into a facility, which has to accept the conservatee. As a reminder, this process is, in theory, guided by a clinical and legal determination of grave disability, someone's inability to meet their need for food, clothing, and basic shelter as a result of mental illness. However, in order to make sense of what happens in this system, I want to introduce a distinction between the power over conservatees and authority over the conservatorship process. So at every step here, you will see powers being exercised by over conservatees who can face forced medication, locked facilities, and physical restraints. And if you talk to people who have experienced conservatorship, they're very quick to say, all through the system, there were all of these people who had this power over me to limit my civil rights. But at the same time, what we see is a lack of authority over the conservatorship process, that all of these actors are kind of following their own rules and their own prerogatives in inconsistent ways. And each of them has a capacity to push someone out of the conservatorship process, but almost no one has the capacity to organize this whole system to get somebody into a conservatorship or to make it effective. So I'm going to walk through kind of step by step a couple of observations about each part of this. So in 2021, I went out with an outreach team assigned to the 25 highest utilizers of emergency services in one California beachside town. In one day, we visited 3 clients who the team universally felt needed to be placed on a conservatorship. But first, these individuals had to be brought to a hospital on an emergency hold, referred to as a 5150 after California's Welfare and Institutions Code. Under the law, a peace officer or a designated clinician can determine that someone is a danger to self, danger to others, or gravely disabled and bring them to an ER for an up to 72-hour evaluation. Our first step was to see Jerry, who fit into a typology I call dying on the streets. He was a chronic alcoholic, he weighed only 80 pounds, and he was now confined to a wheelchair. He was being kicked out of his homeless shelter after walking out of rehab. This had happened before, and he'd been revived by paramedics several times in previous months while passed out on the streets. However, the treatment team is worried that the ER doctors are going to say that his problem is alcoholism or dementia, not mental illness, and quickly release him. We then went to see Jolie, who was in crisis in public. She lived in an encampment that was facing an imminent sweep. When we spoke, she calmly told me about going to the moon with Neil Armstrong before starting to shout racial epithets at an invisible occupant of the encampment. Our team asked her if she wanted housing, and she said she didn't need it because she owned 2/3 of the property in the area. Finally, we visited Guadalupe, who was decompensating at home. She believed that she was being sexually assaulted by aliens, and when she opened the door, she had a long gash on her face that we believe is self-inflicted. She's mute, but writes on a piece of paper she's not interested in restarting her medication. However, the team is worried that because she has an apartment, even if she frequently doesn't stay there, the hospital will just quickly discharge her home. So in the end, who got placed on a 5150? It was Jolie. A few days after I left, a half-dozen police officers showed up to the boardwalk to sweep the homeless encampment. They dragged her to an ambulance while she shouted that they were Nazis. Her case is emblematic of what Chris Herring calls the rise of complaint-oriented policing. You can see on the left a graph showing the increasing number of calls about homeless people's behavior faced by San Francisco police. As California has lessened penalties for drug possession, police have become less willing to use arrests to displace an unwanted population. Psychiatric holds have emerged as an alternative way for police to temporarily clear complaints. A county mental health director explained, police see people who are high, and a 5150 is an easy way to get them off the street. The ER won't admit them, and they come back. The system is kind of functionally dysfunctioning. Meanwhile, for these other kinds of cases, such as people decompensating at home, police are often reluctant to 5151 because their needs are being met by family members or providers in their housing. And that's why police so often advise families to make their loved ones homeless in order to get them in voluntary care. So once somebody's in a hospital, the hospital has to keep them for 17 days before it can apply for a conservatorship. In order to understand how hospitals make those decisions, we have to understand their financial incentives. One interviewee, Kate, was first hospitalized as a teen in the 1980s and described a dying vision of hospitals as long-term care institutions. Well inside, she didn't take medication, but she met regularly with her psychiatrist for hour-long psychotherapy sessions. They kept her for 6 months while waiting to find a step-down program she'd agree to. When she went back to the hospital 2 decades later, though, the approach had entirely changed. She went in and out dozens of times, with most episodes lasting close to the 7-day average length of stay in California. She tried 30 medications, all of them intended to get her just stable enough to discharge. But when she suffered a near-fatal intentional medication overdose, her father convinced her doctor to try to get her conserved. She had, in her eyes, an unlikely savior. A week before her court date, her insurance company wrote the hospital to state that because she was not benefiting from treatment, they would no longer pay. Bless the insurance industry, she confessed reluctantly. The hospital put her on the curb with a plastic bag of her clothing. As the example suggests, clinicians on the ground contrasted their power over patients with their lack of authority over hospital administration and insurance. One nurse told me, "We used to have some very old school psychiatrists. When the utilization review people from administration were like, you've got to get them out of the hospital, they would say, screw you, I'm not listening to you." She sighed. We've had a lot of turnover. Now we have staff meetings where the unit with the shortest length of stay gets a pizza. These financial pressures have a particularly strong impact because of California's heavy reliance on for-profit hospitals. As you can see from the bars here, they constitute nearly 50% of psychiatric beds authorized to take involuntary patients. For comparison, only 1/6 of beds in regular medical hospitals are private and for-profit in California. Now, in theory, the state has significant leverage over these hospitals. I spoke to Phil, whose son Jacob cycled through 5 private hospitals before being quickly discharged home. A month into the 5th hospitalization, Phil recounted, the psychiatrist calls me in and says, "What do you think is going to happen when your son is discharged?" And I said, "Oh, he'll probably be okay for a few months and then he'll be hospitalized again." And he said, "It's worse than that. Your son has a good probability he'll die." Phil reiterated his plea for conservatorship, adding, "He's not welcome back into my home." Phil had learned from NAMI that refusing to take his local chapter, or people in his local chapter, that refusing to take a family member's back is one unfortunate strategy to force the doctor's hand into applying for conservatorship. The doctor replied, "I'll work on it." It didn't pan out. A few days later, he received a call that Jacob was being discharged. Phil has no doubts about what was behind the decision. Basically, it's cost. When a patient checks in, they get reimbursed a substantial amount, but after a few weeks, that goes down. The hospitals would rather have new people coming in because they make more money. I've argued this point. Isn't one good long hospitalization better than 7 or 20 short hospitalizations? And they say yes, but that's not the way it works. In his case, however, he used his contacts that he made through his advocacy to harangue county officials until the medical director of the local mental health department threatened to remove the hospital's authorization to take involuntary patients if they didn't push a conservatorship through. This ability to certify hospitals to take involuntary patients speaks to the hypothetical authority that the LPS Act gives government actors. But as the medical director told me, in practice, counties are reluctant to use it for fear that private hospitals would just switch their beds to serving more lucrative general medicine patients. Thus, as you can see from this chart using data from LA, a much smaller number of truly public county and VA hospitals, which are more willing to eat the costs of holding somebody as they apply for a conservatorship, account for an outsized share of conservatorship applications. So once an application is made by a hospital, it's investigated by a public guardian. Public guardians, again, might seem very powerful, but in interviews, most emphasized how a fixed budget for their offices meant that conservating someone is actually the last thing you want to do as a conservator. As a result, public guardians often define grave disability narrowly. They sometimes would determine that dumpster diving showed a client could meet their need for food, wearing a winter coat in summer heat was clothing, and a makeshift tent constituted shelter. I spoke to Tamara, who started her career at a state hospital and then became a public guardian in the Central Valley. She described a constant hustle to avoid unnecessary conservatorships. As she told me, just because someone is homeless doesn't mean they're gravely disabled. You got to get out there and see what their homelessness looks like. Do they have a tent? Do they have a stove? You go to McDonald's and you ask, do you know this person? Do you feed this person? You go to the recycling company and verify that they're redeeming cans. Tamara's commitment to keeping people out of rights-restricting conservatorships was sincere, but it speaks to local government's organizational imperative to abdicate responsibility for a segment of the homeless population by defining them as homeless by choice or successfully homeless, insofar as they were not generating complaints or driving up emergency expenses. So if an application is approved by the public guardian, it then goes to a hearing. Courtrooms are, in theory, where we should see kind of this tension between rights and care kind of coming into play as an almost direct struggle between lawyers and doctors. And indeed, the LPS Act gives strict legal protections. Courts have ruled then that since there is, quote, little to distinguish conservatorship from incarceration in a penal institution, conservatees have a right to trial by jury and to have grave disability shown beyond a reasonable doubt. And as you can see from some of these images, hearings kind of recreate some of the trappings of criminal trials. In reality, though, these protections are variable. In some hearings, I observed doctors testified about patients that they had seen for only 20 minutes, and overworked public defenders described conservatorship cases as the worst assignment in their offices. In some counties, nearly 3/4 of conservatorships are not contested by the conservatees. When cases do go to trial, the focus is, as at the level of public guardians, often on a very minimalist definition of grave disability. I observed the case of Miss Gonzalez. She's in her 30s, in a wheelchair, and was hospitalized by a county outreach team, who she thought were a group of assassins trying to kill her and the other children of God. Her public defender tried to show that she could meet her need for food. Here's the public defender asked, you testified she wouldn't accept food from the hot team. The doctor says that's correct. Public defender follows up, but she would accept food from people not on the hot team. And the doctor says, well, she might be so psychotic that she thinks they're the hot team. The public defender closes, but she could accept food. In these hearings, references to clients' mental health could be surprisingly rare and ultimately irrelevant. So here the public defender says, where would you seek mental health treatment if you were released? And the patient says, I don't need treatment. I don't have any mental illness, and so I wouldn't go. Finally, the lawyers for the county and the public defender debated what counted as shelter. County counsel says, and you weren't staying in a shelter, were you? You left. And the patient says, no, I wasn't. And the public defender goes on, but you were staying in a bus stop. And the patient says, I was close. Ultimately, the judge concluded conservatorship is not used to conserve people just because they're homeless. I am very concerned about the homeless, but I'm not convinced that our inability to be sheltered is based on a grave disability from a mental illness. The petition is denied. So as with public guardians, our system is organized around abandoning people who can be trusted to avoid heavy service use and who can pledge to provide for their basic needs on their own. In this case, the public defender pleaded with her client to agree to go to a nursing home. Instead, she would be wheeled to the curb of the hospital and released so she could return to near her bus stop. In putting into place a conservatorship, courts also order a person to be placed in a long-term care facility. Locked mental health rehabilitation centers are the main destination for conservatees after an acute psychiatric hospitalization. What gives the MHRCs a vastly different feel from an inpatient hospital I visited is its eerie quiet. The MHRC has no staff psychiatrist. Instead, it contracts for physicians to meet each resident once every 2 weeks. There are no licensed psychologists providing one-on-one psychotherapy. Many of the activities are groups on anger management or living skills put on by program counselors who, the manager of the MHRC tells me, are uncertified people who would otherwise be working at McDonald's. Simon's company, or the company that ran the MHRC I visited, mostly runs nursing homes, but it's shifting towards MHRCs. As the manager explained to me, sure, nursing homes pay more, $800 versus $300 a day, but you can't fill a nursing home. They're always 80% full. He flipped open a filing cabinet crammed with folders. Here we have 12 referrals a week. We have a waiting list of 70 people. Plus, for a nursing home, the feds are always coming to do an audit and claw back funds for adverse outcomes. The regulations for an MHRC are just 7 pages. His quote captures how the state's delegation of responsibility for the long-term chronic care to counties, which in turn have relied on the market, has created consequential power imbalances. California's 58 counties bid against one another for access to scarce beds in facilities like this one. That makes it very hard for them to impose quality controls, since providers can easily take their business elsewhere. Indeed, if anyone who has the authority to decide who ultimately gets served by the conservatorship system, it's these private providers. 2/3 of MHRC beds in California are controlled by just 2 companies, Crestwood and Telecare. As a result, someone with a bad reputation of assaultive behavior or drug use can be blacklisted and have nowhere to go. Teresa's son, who I interviewed, has been on an LPS conservatorship for 20 years, but it hasn't kept him stable enough to prevent 40 5150s and repeated trips to MHRCs. After one long stay, he was discharged to a community provider. They failed to give him his injection, and he was hospitalized again. At this point, she told me, my son had bombed out of several Crestwood facilities, and they said, nope, he can't come back because he acted out. Her son was so frustrated, she said, that he lashed out, got arrested for violence against staff, and spent the next 4 years bouncing between solitary confinement and the forensic wing of the hospital. As she told me, this was the prime example of the risks of having private companies like Crestwood and Telecare monopolizing this whole thing. The private organizations get to decide who they'll take and say, nope, we're not taking you. You don't look good on paper. The result is what Teresa, I think, quite eloquently called a human logjam. Well, earlier in this talk, I probably made it seem like it's impossibly difficult to get someone into a locked facility. This is not necessarily due to a scarcity of beds. Instead, at every level of the system, people are stuck in restrictive settings for lack of a step-down provider willing to take them. The harms, even for people who may need the intensive supports of something like conservatorship, are undeniable. And so for the last very brief part of my talk, I've been talking to you for a while, I want to discuss what abdicated authority means for the prospects of reform. So we're living through a broad shift in our society's response to mental illness. I'm documenting this in ongoing work that is cataloging the more than 1,600 bills on involuntary treatment that have been introduced in state legislatures since 2011. And as you can see here, the number of bills passed into law went from around 50 in 2011 to over 100 in 2021. Blue states like California, New York, Oregon, and Hawaii are leading this trend. Politicians are presenting bills around involuntary treatment as a needed course correction, necessary in particular to help reduce homelessness and divert people from the criminal justice system. Civil rights advocates, however, portray these bills as a pendulum swing back to the bad old days of mass incarceration. However, my research suggests that these reforms frequently fail to live up to both the hopes of their backers and the fears of their detractors. So some of these issues were particularly evident in discussions of SB 1045, a bill that passed in 2018. It intended to create a new pathway onto conservatorship for people who had been 5150'd 8 times in the last year who were suffering from both mental illness and substance use. I saw how a new rhetoric that people are dying on the streets had given a sort of a kind of justification for more left-leaning legislators to support bills like 1045. State Senator Scott Wiener from just right south of you in San Francisco stated at a press conference, allowing somebody to deteriorate and die on our streets, allowing somebody to sleep in their feces, that's not progressive, that's not compassionate, it's frankly the opposite. There was an undercurrent, however. Even in progressive cities, constituents were fed up with high visibility homeless people consuming city resources. At one hearing, for example, first responders testified about a meth user who sat in his wheelchair in excrement and had severe abscesses. They reported he had 120 contacts with the fire department and had refused 99 offers of shelter and housing. Supervisor Raphael Mandelman declared, in reference to this individual, these people are on a relentless and costly merry-go-round that carries them from the streets to the hospital to jail and around and around and around. It is inhuman, it is expensive, and it has to stop. A voluntary services first coalition mobilized against the bill, distributing posters like the one you see depicting the public guardian as a dog catcher rounding up homeless people. They held protests declaring homes not handcuffs and treat us, don't beat us, citing evidence about racial disparities in involuntary care. Their strongest argument, however, was that for all the references to people refusing care, only one half of San Franciscans who sought drug treatment were actually admitted. Nonetheless, the bill passed the legislature nearly unanimously and was endorsed by 11 of 12 county supervisors. Yet as of March 2023, and this remains true now, only 3 people had been conserved. One person who was placed on a conservatorship was set to be transferred to an unlocked facility, but jumped out of the county car on the way there. For months, they were continuously AWOL, pinging in and out of emergency services and hospitals until the public guardian filed to end the conservatorship. So what happened? I asked government officials involved in the program who told me, well, some hospitals are choosing to participate and others are choosing not to. I'll call when one of our clients is hospitalized and say, hey, are you thinking conservatorship? And they'll say, we don't do that here. In short, San Francisco lacked the authority to make the key institutions in the systems, like hospitals and ERs, participate in this pilot, and they didn't. It speaks to the broader way that legal changes alone can spark huge amounts of fear among people with mental illness while offering very little substantive change. Nonetheless, the failure of SB 1045 has not stopped an accelerating set of reforms in recent years in California, and you're probably familiar with some of these. The first was care courts passed in 2022. These are civil courts that could order people to follow a treatment and a housing plan and obligate counties to provide it. These care courts are now in place in eight counties. And so far, we've seen these courts have seen not that many petitions and have little leverage. The courts don't have a strong enforcement mechanism, although they can refer a person to conservatorship. Conservatorships themselves are supposed to become easier to get. SB 43, passed in 2023, changed conservatorship criteria to add substance use disorder and include medical care and personal safety alongside food, clothing, and shelter as a basis for grave disability. But currently, 56 of 58 counties have delayed implementation of the law, citing capacity limitations. And that's why Prop 1 is so significant. This voter initiative, which very barely passed, as you probably know, will allocate $6.4 billion for new beds, some of which can be in locked facilities. Because my own research suggests that the definition of grave disability expands or contracts based on available resources, this will probably be the most significant of these reforms. Okay, so I want to summarize a few of my not very uplifting findings. So the first is to recognize that California's system is oscillating between 2 very problematic poles. So the first is what sociologist Neil Gong calls tolerant containment, the philosophy that it's fine to let people refuse medications or overdose in supported housing as long as it's out of sight or out of mind. The other pole is what anthropologist Andrea Lopez calls brutal compassion, intensive interventions like conservatorship that step in only when a person is on the edge of death and no longer able to accept services voluntarily. As I've tried to show, this stems from the structure of the conservatorship system. While many actors can impose short-term constraints, such as a 5150, they can largely only block a conservatorship. No one really has the authority to push through a conservatorship for someone who really needs it. The third is that, as I just said, as much as the definition of grave disability has become a topic of very intense and acrimonious debate, I don't really think it's defined by the legislature, clinicians, or judges. Instead, a strict definition of grave disability is being imposed on the state because of resource limitations. Fourth, while private providers have stepped in to fill the gaps left by the state, they are not functioning as a public safety net. This delegation of the highest levels of care to the private sector with very limited regulation allows private preferences to drive who gets served in the system. And finally, our overwhelming focus on access to care can crowd out discussions of quality and dignity. When I did interviews with people that's subjected to conservatorship, for many of them, the most important thing was not their legal status, but it was the extent to which they felt listened to and respected and had their preferences taken into account, even if they were subjected to involuntary care. Okay, so that's been obviously like mostly focusing on problems. What are some solutions? As a sociologist, I'm not sort of here to elaborate really specific policy recommendations, but I want to offer a few guiding principles. The first is that I think that probably fighting over LPS criteria is kind of a high conflict reform with a pretty low payoff. I think that focus should actually shift towards effectively implementing existing law. Currently, there's no dedicated state official responsible for the involuntary treatment system. I think there needs to be a dedicated leadership for LPS conservatorship, promoting best practices, setting objectives, and collecting data. That should include also research and pilot projects to better understand who benefits conservatorship and what elements of it are most beneficial. So for example, there's a program in SF called Community Conservatorship, which really focuses on medication compliance while allowing conservatees to live in a community. Second, I think that Prop 1 money should be used to fill out what I call the missing middle of the continuum. Currently, we have many people who are being inappropriately placed in acute settings because they're not ready to step down to a very unstructured setting like supported housing or a shelter, or people are inappropriately in supported housing or shelter, but they need some higher level of care. And I think there needs to be an investment in kind of mid-level options, which would be things like intensive, unlocked residential treatment centers that give people the kind of skills they need to manage their mental health and survive on the outside. Third, I've really wanted to, I've talked a lot about this, highly privatized system, and I think there's a huge need for the state to regulate the system of contracting between providers and counties that is really complicated, unfair, and inefficient for all of the actors involved. I also think there's limits to how much we can delegate care to the private sector, and there needs to be a public backstop like the state hospital with a mandate to take the most complex individuals who otherwise have nowhere else to go except for maybe jail or prison. Fourth, now we're dreaming big. The state should create an entitlement guarantee, which is something that exists for people with developmental disabilities, so that people will only be conserved when they've been considered for a full suite of high quality alternatives, like housing that heals, psychiatric advanced directives, or high intensity full service partnership, our kind of most intensive level of voluntary outpatient care. Finally, I think the system needs a more realistic approach to service resistance. This idea of anosognosia and insight, the fact that some people with mental illness don't recognize their illness, I know that that's something that is just sort of extremely present in the lives of anyone navigating this system. And I think that we need a system that takes that into account alongside recognizing the other reasons people are denying services, which could be that they find the services not culturally competent, they've had traumatic experiences with it in the past. And I think as a result of that, we need a system in which people's files are not closed just because they said no 3 times. We need funding mechanisms that allow for persistent offers of services and building relationships that work relentlessly to get people to yes. And mental health services need to lead with meeting people's needs as they define them, rather than simply, prescribing medication. And so on that note, I'll express again my gratitude for being here. I'm happy to hear questions, comments, concerns, and critiques. And certainly if you feel inclined to buy my book after this talk, you can go directly to the press and use code CUP20 at checkout to get 20% off.